file. I have to file a rejoinder to it, but let it come after something. They have filed an affidavit and I have taken consent.
When will you file?
They have filed, my lord.
When will you file your rejoinder?
My lord, after 2 weeks, my lord, I have to call for the.
After within 2 weeks you'll file, you mean? Or within 2 years, within how many months will you file?
2 weeks.
You said after.
After 2 weeks, my lord.
After 2 weeks, but within how many weeks?
My lord, within
After
the-
2 weeks
within,
can be
within
the
October,
kingdom
within
come.
October, I will file it.
Yeah. You file it within 2 weeks.
Yeah.
Okay, right. Mr. P.K. Roy Chaudhary is granted 2 weeks time to file rejoinder affidavit. This is the matter after 2 weeks.
All right.
That's it. In item number 1 and 2, I am appearing for Mr. R.K. Fuyal also. His brother has expired yesterday.
Who's R.K. Bhuyan?
He is for the sole respondent also.
It's for the sole respondent. Who's the respondent?
Husband also.
Husband, okay.
And for the petitioner lordship.
Yeah, for the appellant you mean.
Appellant, Your Honor.
Appellant is the wife.
Yes, Your Honor.
So what to do? When do you want?
On 16th of October also.
16th. That week will be a motion day,
10th of October.
10th of October.
right? Miss
P. Chakraborty.
P. Chakrabarti appears for the appellant, bracket wife. Full stop. Mr.
A.D. Chaudhary also.
A.D. Chaudhary prays for adjournment on the ground that the counsel for the respondent wife
Yes.
is under bereavement, due to the death of his brother. Full stop. Accordingly, list this matter on,
10th of October.
accordingly on the prayer, the parties list this matter on 10 October.
Obliged lordship.
Who is-
Respondent husband also.
Acha, respondents,
He's for the boy.
Husband.
Lordship has dictated that.
Acha, is for the boy.
Yes, yes.
You mean the husband's brother is under bereavement?
The
The
council.
council.
Acha, the respondent bracket husband's
Yes.
brother, is okay, that's all. Respondent's husband, that's all.
Obliged lordship.
ठीक है. So we admit this,
Madam,
heard Mr.
M.A. Chaudhary, madam.
M.A. Chaudhary, learned counsel for the
Applicant,
appellant, who
applicant.
submits that the judgment dated 7/8/2023 passed by the Court of Sessions, Karimganj in Sessions case number 63 of 2016, arising out of Badarpur PS case number 196/2012, by which the appellant has been convicted under section 148/149 IPC, 324/149 IPC, 307/149 IPC, and under section 302/149 IPC should be set aside.
Yes, madam. Madam, as arms act is also there. He was also
Those and will be now only. And which is the Arms Act?
Section
And
25.
section 25 bracket 1 dash capital A of the Arms
27.
Act.
Oh, yes.
27.
27 is also there.
And
Oh,
27.
and 27 bracket 1
Of
of the Arms Act. Should be set aside. Admit the appeal, call for the LCR. Ms. L. Jahan, additional PP appears for the state. List the matter after
Yes.
4 weeks.
4 weeks.
Then
I,
how much time?
3 weeks.
Ms. L. Jahan, additional PP is granted 3 weeks time to file her written objection to the application under section 389(3).
383.
389(3) CRPC. This is the matter after 4 weeks.
EPF.
So paper book has to be made,
I have received the paper.
prepared. So
Yes.
given to you. So we
Yes.
list it for hearing.
Yes. I've also got it.
Okay, right. Miss
Yes, Roy.
S. Roy, learned legal aid counsel, and Miss S. Jahan, additional PP, submit that they have received copies of the paper book. So accordingly, leave this matter for hearing in usual court. Yes,
6 years.
Lordship, in this matter, we have taken steps against the respondent. Steps were directed to be taken, steps have already been
who
taken.
is the respondent number 2?
Is the
You know, I
informant-
can appear. I think this is an NDPS matter.
What is this? Who is the respondent number
is
2?
a police
He's the
officer.
police personnel.
Police
He-
Oh, what is there?
No,
Nothing.
no,
There's nothing.
Not required.
Not
In
required.
fact, there are two analogous.
You have
matters.
already, in fact, the first order passed by this court, you
Yeah.
have already accepted notice on
so-
behalf of the respondent.
Oh, yes, not required.
But we are directed to be taken, so we.
I know, I read.
Lordship.
But then there is a mistake. I think records were called from the POXO court.
Yes, Lordship, as per office
This
note dated
is-
29, Lordship.
But then the records are here.
Records are here.
Records are
So
here. There
PP,
is.
paper book should be made.
Lordship,
Is it required?
yes,
Yes,
Lordship.
yes.
Okay, right.
In fact, there is an analogous matter where 389 application was already heard and reserved for. Their order was reserved for.
Okay, right. Mr.
AK Boro, Lordship.
A.K. Boro. Appeal on behalf of the appellant. Pusta. Miss L. Jahan. The additional PP submits that she has already accepted notices on behalf of the respondents, on behalf of both the respondents.
Hmm.
As reflected in the order dated 21/6/2020. Pusta. In that way of the matter, notice deemed to be served on both the respondents. Pusta. As the LCR has arrived.
In connection with the other case, it's not here,
Oh, not
but
with
there
this
is an
case.
analogous case which is criminal appeal number
As
171.
LCR has, I know it is stated at the bar that LCR has been received by the registry in connection with an analogous appeal, that is
And 171 of 23.
criminal appeal 171 of 2023. Full stop. Thus, the paper book made in respect of CA 171 of 2023 can also be.
Now, their paper book is yet to be prepared, only bail was heard. Paper book is not prepared,
Not prepared.
all the matters, yes.
No, of course, whatever I said, as such, the paper book to be prepared in respect of criminal appeal 171 of 2023
Hmm.
can also be taken into consideration in this
Yes.
case, full stop. As such, if paper book has not been prepared in criminal appeal 171 of 2023, paper book should be made. As the issue in both the cases, no, as the recovery of the drugs in both the cases pertain to one and the same recovery.
Same judgment, one judgment only.
And both the appeals have been decided. And both the appeals have arisen from the same judgment and order passed by the NDNPS court,
Special judges.
by the special court NDNPS.
I is there pending.
Lordship, may, if possible, fix the IA this Friday, Lordship.
I have filed objection, it's on record.
Why Friday? Why not now? Why waste time? List the matter after 4 weeks. Then in the IA, yes, we can hear the IA now.
Lordship, my senior is having some personal little bit.
We'll wait for him.
Lordship.
We'll wait for him.
Lordship.
We'll wait for him. Because Friday I won't be here. Only Friday.
Oh, he is there.
Huh?
For the NDPS matter.
Oh,
Mr.
we can hear the NDNPS. That we made item 6.
389.
Yeah.
Can it be taken off Friday, my lord? I have
Friday
no,
is not
because it will take some time, my lord. And I'm also not fully prepared. my lord. Can it taken on Friday?
Friday, this court will not be sitting on Friday.
Then for Thursday?
Okay, this is a matter on Thursday. Then in the also in that other, we make it Thursday. In the main. Item 7, give me item 7. Yes, so paper book has to be made.
My lord, objection has been filed, my lord.
Oh, fine.
Objection filed. So paper book,
My lord, I have prepared that the prosecution with testimony in the IM, my lord,
okay.
in English, my lord, I translated, my lord. Here what is happening, my lord, there were 16 total witnesses.
No, no, okay, wait.
Sorry, my
Are we going to do the IA or what?
lord. IM, my lord.
IA.
IM.
And so is paper book required to be made for the main appeal?
For the main appeal required. my
It will be required.
lord. Required.
Okay, right. In the main appeal, you're right. As the LCR has arrived, registry to prepare the paper book, list the matter after 4 weeks, then now in the IA. Give us the IA. So IA we can decide.
IM, my lord, yes, my lord.
IA we can decide. Okay.
In the IM, my lord, what has happened here, my lord? There were total 16 numbers of accused persons in the case, my lord. 15 have been acquitted, my lord.
15 have been, 16 number of accused.
15 have been acquitted, one has been convicted, my lord. It was charged with a 30 to
16 accused,
116 accused, my lord.
oh, 15 acquitted.
my lord.
Ah.
The charge was 30 to 149, my lord. Then sentence on 30 to simplicity, my lord. My lord, I would only, my lord, prosecution has adduced 2 sets of evidence, my lord. One set has implicated me, my lord. The other set has implicated prosecution witness number 2. Lord, in that event, my lord, my conviction cannot be sustained, my lord. My humble submission would be that, my lord. I have a judgment to that effect also, my lord. I will take my lordship to only 5 witnesses, my lord. May I, my lord?
You have been convicted under which section?
302, my lord.
Yes, sure.
The judgment, my lord. In the
Yes.
judgment.
Judgment or the witnesses?
No, witnesses I will show, my lord. In the IM, my lord. Page 18 is the PW2, my lord.
Yes,
I would only read the chief, my lord.
yes,
I know the complainant and the accused persons. I also know the deceased. My lord, can I skip, my lord? The last
Yes.
4 lines, my lord. At that time, deceased Alimuddin, he was the
Yes.
deceased, my lord, was with us, and he prevented the accused persons. Then accused Jabed Ali assaulted Alimuddin on his head with an axe. Jabed Ali is the appellant before your lordship, my lord. Kudus, Nur Jamal, Moinal, Abed, Ainal, Monser, Nawab assaulted Alimuddin with bamboo lathi. They have been acquitted, my lord. Alimuddin sustained injuries in different part of his bodies, my lord. But in the cross, my lord, was you kind on page 20, my lord.
yes.
What you have seen, my lord, page 20, my lord.
Yes,
Third line, my lord, it is not a fact that when the villagers prevented us from doing construction works, I brought one spade from the shop of one Kalumia and attempted to assault Kudus Ali Mahari. And at that time,
who is this
Alimuddin,
Kudus?
Kudus is from the accused side, my lord. Alimuddin came forward and the spade blow fell on the head of Alimuddin and he sustained injuries. My lord, again, turn it on to page 22, my lord, PW3, my lord.
Page 20?
22, my lord.
22.
22, my lord.
Who is this?
He's a uncle of the PW2, my lord. Page 22, my lord.
Yes,
Watch it, 5th line, my lord. I started moving towards Bilal's shop.
yes,
Watch it, Bilal is prosecution witness number 13, my lord. Arriving there, I saw Jabed Ali dealing blow on Alimuddin's head with an axe. He dealt the blow with the sharp edge of the axe. As I moved further, Abed Ali dealt blow with a lathi aiming at my head. But as I bent my head, the blow landed near my eye. I became unconscious. I was taken to Kukurmara hospital. What will can you turn the page, my lord, page 23, my lord? The last line, my lord.
yes.
It is not a fact that Moinal is PW2, my lord, dealt blow to Moharar Kudus with an axe, and when Kudus obstructed him, the blow landed on Alimuddin's head. The rest I would not read, my lord.
So what do you want to show by this?
My lord, lordship has seen the suggestions, my lord. And specific role has been attributed to the appellant, my lord. And also to the other accused persons, but they have been acquitted, my lord. But you can you turn to page 72, my lord. I beg your pardon, my lord, page 71, my lord.
Yeah.
She is a villager, my lord, independent witness, my lord. I would show her cross part, my lord. It is hearsay, my lord, but she has heard this, my lord. Kindly, my lord. Cross, my lord. Fourth line, my lord. I heard that one person, what she was found, my lord,
Yeah.
had taken away one axe from the shop of Bilal, PW13. Later on, I heard that Moinal Hussain had taken away the said axe. Moinal Hussain is PW2, my lord. My father's house is adjacent to the house of Ali Muddin and Moinal. I heard that Moinal inflicted a blow with the axe on some other person, and at that time Ali Muddin tried to rescue the said person, and the blow fell on his head.
This is a hearsay.
Here's my lord. Again, I'll watch you turn the page, my lord. Page 72 is PW 13, my lord. Watch will turn the page to page 73, my lord. It's cross, my lord.
Cross of PW12.
PW 13, my lord. Page 73 is cross of PW 13, my lord. Well, fourth line, my lord. You will see, my lord. Moinal got one axe. What you will see, my lord. Page 73, my lord.
Page 70.
3, my lord.
Yes.
Fourth line, my lord.
Yeah.
Moinal got one axe from the shop of Bilal and attempted to inflict a blow upon Quddus by saying that in spite of being local people, he did not look after the work properly. And at that time, Ali Muddin came for work to rescue Quddus, and the blow of axe fell upon Ali Muddin and he sustained injury. Watchable again, can you turn the page, my lord, page 74, my lord. He is the shop owner, my lord, where the place occurrence took place, my lord. PW 40, my lord, Bilal Hussain, my lord. I know the informant and the accused person. Lordship is clear.
Yes.
I know the informant and accused persons. 11-12 years ago, incident occurred at 2-3 p.m. One day, I was at my shop. Road repairing work was going on. That time, quarrel took place between villagers of Bamunpada and Musal Dangar. Moinul took an axe from my shop and hit Ali Muddin thereafter. Police recorded my statement. Cross, my lord. 400-500 persons gathered there. At the time of incident, Moinul, son of Amir Hussain, tried to hit sudden but hit Ali Muddin accidentally.
So this Moinul and
PW2.
Moinul and Ali Muddin, are they from the same side or from
Same
different?
side, same side, my lord. There was a road
So-
construction. If lordship is the entire evidence, my lord, there was a road construction work going on. There was some dispute regarding wages, my lord. A fight broke out, my lord. The London court below has laid upon 2, 3, 5, 7, and 8, my lord, to convict me, my lord.
2, 3, 5, 7, and 8.
Yes, my lord. Yeah, well, 2, 3, 5, 6, 7, and 9, my lord. Sorry, my lord.
2, 3, 5,
6, 7, and 9, my lord.
6, 7, and 9. Okay.
My lord. 5, 6, 7, and 9 have been duly contracted before the IO, my lord. 2 and 3 remain, my lord. 2 and 3 are one set of evidence which are saying that the appellant has caused the axe blow, my lord. And there is a separate set of evidence, my lord. Independent witness, my lord, was saying that PW2 is the one who inflicted the injury on Ali Muddin. When he tried to hit somebody else, Ali Muddin came in between, my lord. He was hit, my lord. PW 14 is the shop owner from where the axe was taken, my lord. I have read him out, my lord. May I place only one judgment, my lord? Well, this is 2002 2 JLT 103, my lord. Para 24, my lord.
Yes.
Para 24, my lord. Which was found, my lord.
Yes.
Coupled with the above, we all have to also bear in mind that when prosecution adduces two sets of witnesses, one contradicting the other, and the court is not in a position to hold confidently as to which set of witnesses has told the truth, then both sets of witnesses have to be discarded, or at least the set of evidence which goes in favor of the accused shall be adopted by the court. Keeping in mind this salutary principle of criminal law in mind, when we revert to the case before us, we find that the evidence given by PW2, one of the facts of that case, not only projects Mangamura alone as assailant of the deceased, Ashok, but it rules out the possibility of the present appellant having shot the deceased with the arrow or having helped.
Now, in this case, since there were a fight between two sets of persons, so there are two sets of witnesses. You mean they are PWs and DWs?
No, they're all PW,
Or PW?
all PW.
Then is there a FIR lodged by the other group
There
of
is no-
persons?
I have not come.
Then what do you mean by two sets of evidence?
My lord, in the same prosecution witnesses, my lord, there are two sets of evidence, my lord. One set implicating the accused, my lord. The other set is implicating PW2, my lord. In the same prosecution witness set, my lord. 90 witnesses were examined, my lord. Two have not been broken in cross.
So this PW2, who is he?
He is the
Moinal Haq.
Moinal Haq is the contractor of that road repairing work, my lord,
Was
due to which
taking the money.
he was taking the money, my lord.
Taking the money from where?
No, for paying,
For that
for
wages,
paying
ma'am.
wages to the workers. Then the fight ensued.
And my lord, 16 numbers of witnesses, accused persons, my lord.
And who is this Moinul? Moinul is different.
Same, my lord.
Same.
Same, my lord, son of
The
Amir
one who took the axe from the shop.
is Moinal Haq, Moinul, my lord, son of Amir Hussain. He makes it very clear, my lord, PW14.
No. So are they same persons or different
Same
persons?
person, my lord. So can you turn to page
The
again?
PW2 is the person who took the axe from the
Yes,
shop.
my lord. He attributes the taking of axe to me, my lord, but actually it was taken by him, my lord. PW14 is the top owner, my lord. He says that. What you can it again turn to page 74, my lord. Moinul, son of Amir Hussain. Moinul, son of Amir Hussain is PW2, my lord. Tried to hit sudden but hit Alimuddin accidentally, my lord.
Page 70.
74, my lord.
The owner said. Owner said.
Shop owner. sir.
Moinul took an axe and hit Alimuddin.
Sudden to the next, right to hit someone else.
No, but he did not.
But whether he is the original.
Yeah, don't know what it is. PW2. I think it's PW2.
Javed Ali assaulted Alimuddin.
13 to
तीन के साइड और रुकना पड़ता
you to see.
है because of this.
Morning, what one next on the shop of the gun is going to be belongs to tools. So seeing the instead of the open of the thing to one person yesterday, and seeing the one. And mostly people on the floor around the
So this cannot be done, mother. Had PW14 been made hostile, my lord,
Just a minute.
How to make a.
two sets of witness अपने 4, 12, 13, 14. व्यक्ति के उसमें तक नहीं सकता है कुछ. पूरे को तो prosecution की ई मारा बड़ी बहुत बंची.
Producer my account, I'm going to back to it.
इतना मजा पता लगे इसलिए ये दाव का है भाई.
But PW2 and 3 are against you.
Even clear against me, my lord, but one set of witness cannot be accepted like that as per the judgment, my lord. If there are two views, my lord, the view favoring the accused has to possibly be taken, my lord. And my lord, specific evidence of the shop owner, my lord, from where the axe was taken, my lord. The PW2 is the one who taken away the axe, my lord.
What does PW14 say in the statement before the police?
For that, I have to find out.
But
Just a.
even then, my lord, he has not been made hostile, my lord. I have not seen the 161, my lord. But if not made hostile, my lord, and relied upon by the defense, my lord. My lord, I have a judgment to that effect as well, my lord. I could not take out copies, my lord.
14 नाम लिखी
14 Bilal.
Bilal. It's very good, right?
So guys, please one more judgment.
Huh?
Please one more judgment.
Huh? Yes, yes. We've got it.
Mimic. Forwards is very right. This is a file B GR case. File A GR case. Okay. File A, sorry.
Second case, 93.
Sessions is okay.
So, let me over here to you.
That's it. Listen, brother. AJ minor session. AJ minor session. Sessions. It is GREB. That is one session is very nice. Okay, here's just different with answer. The photo statement. Accused of statement. Every accused of statement is in the judicial super. Heavy doesn't. You push the copy. Case died to people. I do any of I say. Oh, yeah, me. Case died tonight to people. Some protested copy of I say name. Hello, case died to people. That is an statement. I don't know one way. It's me, Pan officers. Bilal.
Five, four, five. मतलब क्या है?
And someone check this person. It was my
He also is against it.
That's why this was not It's very separate.
Huh?
My lord,
Can you find the case diary in the case record?
Huh?
my lord,
Yes, but
take no lost part to interrupt, my lord. There's another judgment, my lord. My lord, may I please line?
yes, yes,
That is called Saha Alom, my lord.
Huh?
Saha Alom, my lord. Our
yes, yes,
para 39, my lord.
yes.
Petition
Uh, 21-4-104.
21-4 SSC.
Jail,
BNK.
Para-
104.
4-3. Para 39, my lord.
Tara?
39, my lord.
Yes,
What you will find, my lord, PWs 2 and 3. 14th line, my lord, of the para, my lord. PW 2 and 3 have not been declared as hostile
yes,
witnesses by the prosecution. If that be so, in view of the decision of the Supreme Court rendered in the case of so and so, my lord, the evidence of PWs 2 and 3 would be binding on the prosecution, more particularly when relied upon by the defense side. Viewed from that angle, we find that there is evidence on record to establish that the accused person was not in his house when the incident took place.
what was stated in this,
This case is-
Rajaram?
This case is, Rajaram says that, my lord, when a prosecution witness has not been made hostile, my lord, and the defense relies upon him, my lord, it becomes more binding on the prosecution, my lord.
Where is that?
My lord,
Your basic case is only with regard to PW 12. Your case is basically relying on PW 12.
third,
13, 14.
PW 12, 13, 14, my lord.
13, 14.
PW 4 also says in cross, my lord, but I have not shown him because it's in cross, my lord. It's there, my lord.
What does 13 say?
13 says in cross, my lord.
Ah,
Page 73, my lord.
12 is hearsay, correct?
12 is hearsay, but she hears this, my lord, from her village people, my lord. She's independent witness, my lord, and the ones
No.
who interpreted me, my lord.
Hearsay is hearsay.
Yes, 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 yes.
Hmm.
Page 73, my lord. It's 12, my lord. Monal got one axe from the shop of Bilal and attempted to inflict a blow upon Kudus by saying that in spite of being local people, he did not look after the work properly. At that time, Alimuddin came for work to rescue Kudus, and the blow of axe fell upon Alimuddin and he sustained injury. But 14 cannot be disregarded. Malay. He is the shop owner where the occurrence took place. No? All PW say so, man. Fourteen is script. Page 74, man. Moinul took an axe from my shop and hit Alimuddin thereafter. Police recorded my statement. In cross, Moinul, son of Amir Hussain, tried to hit Sudden but hit Alimuddin accidentally. My lord, all others have been acquitted, my lord, on the same set of evidence, my lord. There is categorical evidence against the other accused persons as well, my lord. But the learning the court below did not convict them, saying that there is no corroboration as per the names.
There is no 161.
There's no one say, I couldn't get the case diaries here, but that this needs to be looked into. Why case diary is not here? There are two files of GR case, which is file A and B, sessions case A and B, and some split up case record. Where there is only the FIR and the charge sheet. Lordship can have a look once, Lordship, they will know.
Well, may I show that paragraph where the learned court got disregarded PW 14, my lord?
Yes, what do you say, madam?
As far as the eyewitnesses giving different accounts, Lordship has to see which ones are believable. Now here 13 and 14 are the shop owners. He said that in front of their shop the incident occurred. But 2 and 6 are the contractors who actually had brought the money from whom it was alleged to have been snatched, and then the fight ensued and they had seen. Moinal and Abbas, they are the contractors. They had said in very clear terms that it was Alimuddin who had hit on the head of the deceased. Others were involved, they had hit by bamboos and all. Evidences were not very clear, and that's how they were acquitted. But as far as giving hit on the deceased, it is stated by both Abbas and Moinal that he had given Javed Ali. As far as shop owners, what they said that X was taken and then accidentally it fell on Alimuddin. They were onlookers. They were in the shop. And the sketch map will have to see whether the incident exactly took place in front of their shop.
So I can read the PW's, my lord. Everybody says Bilal's shop, my lord. And PW 6 has been duly contradicted, my lord. He does not say my name, my lord.
And this complainant's evidence is also there, PW1. He had also stated Javed Ali gave the blow.
PW 1 has been disregarded, my lord, because in cross he says that I do not know who hit whom. I cannot say.
Evidence of
So
4, 5, 6 also is against you, I think.
2 and 6.
4 is not against me, my lord. 5 has been contradicted, my lord. 6 has been contradicted, my lord. 7 has been contradicted, my lord. 8 has been contradicted, my lord. Only 2 and 3 remain, my lord.
But 2 and 6 are the evidence. 2 and 6.
6
No,
has been
no, no.
How do you say they've been contradicting their statements?
There were put specific suggestions in the cross, my lord. Have you stated? They said it is not a fact that we have not stated. Then before the IO, my lord, IO has proved the contradiction, my lord, by saying that
Where is the 161 statement? We'll have to see.
That's it, Justice Nandi got it perhaps. But those were photostat copies. Those are in the accused statement. Witnesses. There I did not get Bilal Hussain. Bilal got, Lordship got it. Oh. Oh, this one I didn't see. Oh, acha. Bilal Hussain. The pages are, it's finished. Acha. This is totally torn. Cannot read.
Somehow you can make out.
But
Try and make out.
Bonale, Anna, Parasity. She is better in reading this. Looks torn. Don't know. This is Bilal. মোৰ নামো ঠিকানা
যোৱাকালি 22 Lordship will understand.
If she understands, it's okay.
যোৱাকালি 22/3/2011 দিনৰ অনুমান 2টামান বজাত মই চাহ দোকানত আছিলো এনেতে দোকানৰ পৰা half thing is torn মানে এনেতে দোকানৰ পৰা প্ৰায় 20-30 গজ ৰাস্তাৰ ওপৰত হাল্লা চিল্লা শুনি দোকানৰ বাহিৰ ওলাই আৰু দেখা পাও যে বামুন আছিল বামুন পাম চলডাঙা কিছুমান মানুহৰ লগত কিছুমান মানুহৰ লগত মই
Yes, Moinul took an episode. A last of me. Javed, Kodupia, Javed Ali, so and so, sober, Namli. Ali, so these are all names. Ali, Obhiju, Hol.
Dukanor.
Does he say that Moinul hit the Alimuddin?
Lordship, Moinul's name is missing here because half page is torn, my lord.
Etu ki dise etu?
Yes, the Moinul's name is, we could not find it, my lord. Because
These are,
half page is not there.
because these are all Ali.
Moi, Abdul Salih Pura. Dukanor.
মোৰ দোকানৰ পৰা দা লৈ যোৱা কিবা আছে।
Dukanor, Pala, Lutar.
Even someone taking X from his shop is also not there.
আৰু ইজন কোন there? 13 জন কোন? 13 or
Nitul Mia.
Mitul Mia.
Pala কেনেকে ধৰিব পাৰি?
থাকি থাকি পালি গ'ল। We'll see PW2 statement once Mitul Mia. He also said the same thing. Mitul. অৱস্থা চাম। I didn't think this
Mitul Mia
was.
is number 13,
Huh.
PW 13.
Mitul Mia.
What is Moinul to?
Moinul নহয়, Moinul to আৰু
Moinul, this,
Moinul witness.
Moinul, Moinul.
Moinul is PW 2.
He is different.
আৰু এজন যে কৈছিলে,
এজন বেলেগ, এজন হেৰি, বিলাল আছে।
okay.
এতিয়া
আৰু নাম, আৰু এটা নাম।
এইটো নাম কি আছিলে? কি আছিলে হেৰি? মিতুল মিয়া। মিতুল মিয়া। বাপৰে।
আৰু এটা piece কৰিব।
প্ৰথমৰ পৰা চাই যাওঁ নেকি?
And my lord, this is not first time in appeal, my lord. This defense has been taken all throughout the trial, my lord. All witnesses have been put this action, my lord.
Maybe, but let us see.
এইটোৰ অৱস্থা এনেকুৱা। আব্বাছ আলী।
Abbas.
আব্বাছ আলী। জনছৰ আলী।
Moinul, Moinul নহয়।
আৰু পালো। চনোৱাৰ জাৰিৰুল।
Moinul হক।
জাজিজুল।
জাসন আছে।
জেছন। এইটো বিলালটো যে কৰিলো।
আৰু নামটো কি?
মুতুল মিয়া।
Moinul হক।
PW 13, Mithul Mia, THUL.
Yeah, Mitul Mia. This one I can read out.
Hmm.
কালি হৈ গাঁৱৰ ইমান কথাৰে মই জানো মতে মই জনা মতে আমাৰ বামুণ এখন গাঁও আব্বাছ আলীয়ে ৰাস্তালৈ ফুল নীল সমান আনি কি কৈছে মিতুল মিয়া কি কৈছিলে?
Only in cross, she says, only in cross.
Yes. দিবলৈ গৈ ইংৰাজী ইমান তাৰিখে
Mithul Mia.
চেক মই দেখা নাই then মই
You've not seen anything.
yes মই জনা মতে হেৰি কাম কৰা Abbas Ali, no, he did not say anything. He simply said.
Then
"I
how
heard
come,
there
how
is
come,
a-"
then in his cross, how come he says all this? Cross he gave, so he's not there in the 160.
No, nothing. He simply said, I heard there was a fight
Ah,
and Abbas Ali and Etu Sasun Peri.
Okay.
He can also cross check. It's a small statement.
he was not present.
ইমান তাৰিখে vote ইমান তিনি মাৰি নেকি চেক নাম্বাৰ ঘাটৰ টকা এয়া 1.5 লাখ টকা Moinal gotten, it is not a fact that on the It is not a fact that on the day of occurrence, Moinal will present with me.
Full stop is there, no? That is the problem.
Full stop
there.
is there, but
Just
Moinal got
suggestion was
one
that-
X.
As suggestion was that Monal was with him, my lord.
But anyway, it's not there in the statement and said that he was not present.
He was not present.
So
He
where's
heard
the
it.
question of, if you are not present, where's the question of seeing the incident?
He was, whether he was present. মোটেও শোনা গেল, এটা মিটুল মিয়া।
It is not a fact that on date of occurrence, Monal was present with him. He was there at the place of occurrence, my lord.
No, no, it is not a fact that on date of was present. It is not a fact.
It is
He
not
was
a
not
fact.
there.
Not a fact, my lord, but
Ah,
that, my lord,
so he was, Moinul was not with him also.
Monal was not with him, my lord, but
Mr. Council, 161, what does it say? That's all. We are looking at 161. We will see that. You cannot say that there are contradictions with regard to others and no contradiction with regard to him.
Saying
When it is not mentioned there in this
that-
161.
এই জায়গাত আছিলে নি নাই?
বেলেগ কথাই কৈ আছে। Regarding some work, he is talking about some
work.
work.
the fight
He
was.
brought 10 lakh rupees, yes, those are there.
So seeing the incident, may I read my?
Yes,
note?
yes.
I'll try to read it. মোৰ নাম ঠিকনা so and so, it is statement of মিতুল মিয়া। মই মানকাছাৰ PK and কোম্পানীৰ এজন কি হয়? অ,
গাড়ীৰ নেকি?
মই কোম্পানীৰ হৈ বামুণপাৰা গাঁৱৰ মাজেৰে যোৱা পথটো পকীকৰণৰ কামৰ চোৱা চিতা কৰো। মই জনামতে আমাৰ কোম্পানীৰ পৰা বামুণপাৰা গাঁৱৰ আব্বাছ আলীয়ে ৰাস্তাটোৰ বাবে শিল যোগান ধৰা পাৰ্টিটোক টকা দিবলৈ যোৱা ইংৰাজী 21/3/2011 তাৰিখে হাতশিঙিমাৰী ষ্টেট বেংকৰ চেক নম্বৰ চয়েনচল মুঠ 1.5 লাখ টকা উলিয়াই লৈছিল বুলি মই জানো। কিন্তু যোৱা ইংৰাজী 22/3/2011 তাৰিখে উক্ত 1.5 লাখ টকা কোনে কাঢ়ি নিলে মই দেখা নাই।
Who snatched away, he did
মই
not see.
জনামতে আমাৰ কোম্পানীৰ ৰাস্তাটো কাম
Okay, so the
didn't-
weapon was snatched away.
regarding the
নাই, নাই।
weapon is doesn't talk about.
Okay.
It talks about the money.
Okay, money.
1.5 লাখ টকা।
That
Okay,
he
okay.
heard, he did not see.
মই জনামতে আমাৰ কোম্পানীয়ে ৰাস্তাটো কাম চোৱা চিতা শিল বালি আদিৰ যোগানকাৰী টকা পইচা লেনদেনৰ বাবে বামুণপাৰা গাঁৱৰ আব্বাছ আলী আৰু কেইজনমানক দায়িত্ব দিয়া বুলি মই জানো।
He simply knows.
Responsibility was given to somebody else, Abbas Ali and somebody.
So he says that he doesn't say that he saw the incident.
No,
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 no.
nothing about. He talks about only money part.
So we are left with the evidence of 2 and 6, Moinal and Abbas Ali. They said he had hit. The only
What about
difficulty
14?
is 14.
14.
The only difficulty is 14, what he said, but in his 161, he did not say anything. Of course, we could not find
There's nothing.
Moinal taking the X from his shop. That is not there.
Okay.
As far as bail is concerned,
Okay,
same
right.
set of evidence, the others are acquitted, but
Okay, heard.
enough evidence.
Kindly,
Mr.
my lord, kindly, my lord, 14, how can 14 be disregarded, my lord?
We'll see.
Kindly, my lord, everybody else has been acquitted, my lord. And my lord, I am not going to that, my lord, 30 to 149, my lord, was the charge. I am convicted under 30 simpliciter, my lord.
No, that
So
can be done.
that
There are,
also is
actually-
not permissible, my lord.
no, there are judgments.
My lord,
where it is- on the,
when
yes.
the entire evidence is, my lord, but when the entire evidence is being laid under 149, my lord,
Heard Mr. A. Chowdhury.
and Mahajan, my lord. My lord,
N. Mahajan.
my lord, kindly, my lord. Kindly,
Learned
my lord.
counsel for the petition, for the
Already
applicant.
8 months we have.
And Ms. S. Jahan, additional PP. Full stop.
Kindly, my lord, he already there for 8 months, my lord.
By
Trial
filing
also
this
he was on bail, my lord.
By filing this application under section 389(3) CRPC, comma, the applicant has paid for setting aside the operation of the judgment and order of conviction. This last order, para 2, just take this down, huh? The basic ground for staying the operation of the impugned judgment and order and releasing the petition on bail is that one set of witnesses, prosecution witnesses, have taken the stand that PW2 had caused the death of the deceased by hitting him with an axe, while another set of witnesses had caused the death of the deceased. Well, another set of witnesses had taken the stand that the applicant was the one who had hit the deceased with an axe. Full stop. He submits that when there are two sets of witnesses giving contradictory evidence, comma, the evidence which goes in favor of the accused shall have to be adopted. So in this regard, the learned counsel for the applicant has relied upon the division bench judgment of this court in Budhwa Mura versus State of Assam. Budhua. Mura, Mura. Reported in 2002, 2 GLT 103. Next paragraph. He submits that the evidence of PW 12, 13, and 14 is to the effect that PW2 MD Moinal Haq, Moynal Haq, HOQE, is the one who had wielded the axe that had caused the death of the deceased, while the evidence of PW 2 and 6 2, 3 and 6.
2 and 3, man.
2 and 3.
6 and 3
6.
contradicted.
Huh?
Abbas,
6 and 3 contradicted. 2 and
3,
3.
I don't know, but 2 is 2 and 6
2 and
are the
3
contractors.
Have given their evidence that the applicant was the one who had wielded the axe which caused the death of the deceased. Full stop. He accordingly submits that as the evidence, as PW 12, 13, and 14 have not been declared hostile witnesses, their evidence, which is in favor of the applicant, would have to be considered. Full stop. In this respect, he relied upon the division bench judgment of this court in the case of Sa Alam, SAH Alam, bracket MD versus State of Assam and another 2021 4 GLT 1043. Full stop. Next para. Here, Ms. S. Dahan, additional PP. On the other hand, submits that the
Statement of 2, 3, and 6 establishes.
2, 3, and 6 establishes the guilt of the applicant, in having caused the death of the deceased, as he was the one who had wielded the axe which hit the deceased. Full stop. She further submits that the evidence of PW 12 is hearsay and the evidence of PW 13, which is in favor of which appears to be in favor of the applicant, has only been made in the cross-examination. Full stop. No such statement had been made by PW 13 in his statement under section 161 CRPC. Full stop. She submits that though PW 14, who is the shop owner, has stated that that PW2 had taken an axe from his shop and hit the deceased, the statement made by PW 14 in his 161 statement CRPC does not
Corroborate.
contain such averments. She accordingly submits that the application should be rejected. Full stop. We have heard the learned counsels for the parties. Full stop. The evidence of PW2 and 3. 2, 3, let me see 6. Two, 3, and 6 is to the effect that that the deceased Ali Muddin had been assaulted with an axe by the applicant. Full stop. Next paragraph. The evidence of PW 12 is to the effect that on the date of occurrence, no, whatever I said. The evidence of PW 13 in her cross-examination shows that she had denied the suggestion that PW2 was present with her on the date of occurrence. Full stop. Though it has been reflected in the cross-examination that PW2 got one axe from the shop of PW14 and attempted to inflict a blow upon one Kudus, and the same had accidentally fallen upon the deceased who tried to rescue Kudus. Come on. We are of the view, we find that no such statement had been made by PW 13 in his cross-examination, in his statement given to the police under section 161 CRPC. Further, it appears that it appears that PW 13 in his cross-examination had been answering a suggestion with regard to the blow being inflicted by Moiner on the deceased. Full stop. The only evidence directly linking the death of the deceased Ali Muddin is the evidence of PW 14, who has stated that PW2 took an axe from the shop of PW 14 and hit the deceased. On perusal of the statement made under section 161 CRPC by PW 14, comma, it is found that some parts of the page on which the statement was recorded has been torn. Full stop. Be that as it may, the remaining part of the statement which is in the document does not show that PW 14 had given any statement to the police during his statement to the police that PW2 had taken an axe from his shop. Is it there?
Lordship, in fact, I wanted to say the 161 can be used only for contradiction. So
That's
perhaps it cannot be used in the manner that Lordship is.
right. Okay. Only
So-
for contradiction.
Only for, that cannot be taken now. This is actually a waste paper now.
Correct.
So that
No,
cannot,
but then I'm just, there's
uh,
nothing stated there.
nothing stated there. That is for, of course, that is there. Whatever we could read, there's nothing stated there. But that cannot be taken in this
Yeah.
stage.
In this thing. Because
And
that,
if your lordship thinks that, of course, the evidence which goes in favor of the accused will be the clinching factor. So here 14, of course, it goes in his favor. Others have, suggestions were given and others have rejected that suggestion, saying that no, it is not a fact that Moinul had taken. I've seen in the evidence of few witnesses. So, but leave it to your lordship. But, again, lordship has to see which one has to be believed. And there are more evidence on this side. 2, 3, and 6 were very clear. And the contradiction that he is pointing out about 6, it is not in that context. Otherwise, he had seen. No, both of them have fought together and had hit. That part is not
But
there,
it-
but seeing,
but yes, okay, but this cross-examination, like PW 13, in his
Mm.
cross-examination,
Mm.
he has stated this.
Huh.
Which was never a part of his statement. There's no question of now confronting him
Huh.
with that aspect,
and there is no question, because he did not say anything.
because he did not say it.
But it was the defense of capability of bringing out that statement during the cross-examination. It was good. That will be an evidence. That is an evidence.
So that means he has got a point.
Yes, got a point in my head, because I think so. As far as my understanding
Cannot be
goes,
beyond reasonable doubt.
Why not?
Cannot be beyond reasonable doubt.
have gone on. What is the point? No. What is the point? Because এটা business তার পরে হয়েছে। That will definitely be taken into account. Favorable.
So what have I stated? Full stop. Exactly that. And hit the deceased. Full stop. The above being said, comma. In view of the deposition of the witnesses, prosecution witnesses. And as there is no confrontation with regard to their statements made under section 161 CRPC, comma. The statements made by the prosecution witnesses under section 161 CRPC cannot be considered at this stage. Full stop. However, we would have to go into the evidence of the other prosecution witnesses vis-a-vis the evidence given
PW
by PW 40 with regard to the person who had actually wielded the axe at the time of the incident. Utsav. On perusing the evidence of PW. Okay. Order is out.
My lord, kindly, my lord. My humble submission cannot be beyond reasonable doubt, my lord.
Only that the witnesses has
No,
to be
but you're
seen, who
reasonable.
can be believed. Of
That's
course,
the thing.
PW6 said that incident occurred in the front of Bilal's shop. So
Everybody
Bilal
said-
has all the opportunity to see. But other witness all have stated he had hit him on the head. Only Bilal said it was accidentally done. And 13 in cross-examination. Kudus is an accused with Kudus.
Kudus was for example, that's not seen.
Kudus.
And my lord, all the witnesses were said against me, my lord. They are same family members, my lord.
Who is this Kudus?
In fact, when they tried to hit Kudus, it fell on Ali.
This
Mukhtar. So
Kudus was
Kudus,
supposed to be hit, yes.
Kudus's 161 statement can be there, Nikki.
No, but who is Kudus? Is he a witness?
No, no, my lord.
Huh?
No, no, my lord. Kudus Ali is accused number 5.
Accused, he is the
He has
accused,
been
Accused.
acquitted. He has been acquitted.
acquitted. There can be so many Kudus.
There may be so many Kudus. Kudus Ali is here in PW5. Accused number
And
5.
will she?
Obliged. Ali obliged.
Lordship, this is an appeal preferred by the state of Assam, my lord. There's a mistake on our part. We could not take first step as per the.
Madam, this has, from July.
Lordship, no. Steps we have taken. The no ID card has been received back. We have taken steps on 19/7/2023. And thereafter, there's an order of this honorable court dated 23/8/2023 in terms of Deepak's.
There is no, there is no.
There's an order, your lordship,
Where?
23/8/2023
It's not here, not in this file.
in the I leave application.
India, it's not here, my. Huh?
In terms of criminal bill jail 40
Okay,
2022.
that's up.
So that steps, lordship, there's a mistake on our part. We'll take fresh steps within 1 week, your lordship. Steps taken. No, just taken. Taking Deepak Nayak so much about. Because as per Deepak Nayak judgment.
Correct. I will not, no, we're doing it together.
It will not-
You've got to issue notice in both together.
Yes, sir.
So what to do? Yes, madam, what to do?
Lordship, we'll take fresh steps as per Deepak Nayak judgment. We
How?
need to email it. Lordship, in terms of honorable courts,
Yes, yes.
order, they did 23/6/2022. Para 8 and 8, apa sa copy?
Para?
Para 9, but I have marked it.
Para 9. No, this is with regard to the notice to be issued to the victim or the guardian.
Oh, yes, yes.
That is with regard to.
Yes, but
the-
when to jurisdictional magistrate was directed to be issued on 23/2023. There's an order from this another court, 23/2023. 23 the order. ID card आना था.
It's already there. Yeah, in order to expedite service, the state shall take steps within 2 days for service of notice on the respondent number 2 in the manner provided in paragraph 9 of the order dated 23/6/2023 passed by this court in criminal appeal.
Oh,
So as to be served through the officer in charge of the concerned PS.
yes. But we'll take straight to,
This is.
yeah, this is as regards, my lord,
on
service of
the-
states on the
on the victim.
victim.
Ah.
But this is an appeal against acquittal.
Correct.
But Lordship, since there's the order, we'll take fresh steps through jurisdictional magistrate or through the OC concerned. Because there's an order from his honorable court, because AD card has not been received back. We have Talabana steps we have taken way back in 1907. AD card has not been received back. So fresh steps we will take, your lordship, to the OC.
Okay, right. Heard Ms. B. Boyan, additional PP. Who submits that no steps have been taken in terms of the earlier order dated 23/8/2023. To stop. She accordingly prays for time to take steps afresh. To stop. The prayers allowed. The state shall take steps for service of notice upon the respondents, respondent or respondent,
Respond.
upon the respondent by registered post with AD within 3 days. To stop.
Right.
In addition to the above, the state shall also serve notice upon the respondent through the officer in charge of the concerned PS or through the jurisdictional magistrate or what?
I think it would be convenient for us to issue notice through the OC, no?
Through the officer in charge of the concerned PS
Yes,
and submit a report thereafter.
right.
In both the IAs, huh?
Right.
No, in IA 517, 577 and in criminal LP 34. Both, same order.
May I please allow?
One minute, let me close.
This LCR has come, it was for the Miss case for suspension of the sentence. Where this accused appellant, my lord, he was sentenced for life under section 302 simpliciter. Before going to the evidence, my lord, I'm just giving you lordship the brief description of what has happened. This petitioner, who happens to be the husband of this victim, the lady, the wife. Now, initially, the FIR was lodged under section 304, 498A and 307. Initially 498A and 307, public 34. Then after the charge sheet, they have filed the charge sheet under section 304B. So 304B was in the charge sheet. And during the charge, my lord, that's more important, my lord. They have replaced the trial court replaced the 304B, and instead of the 304B, 302 has been added.
So it's only under 302 now.
So now it's 302. So absolutely it's a case of homicide, my lord. Now, there is a dying declaration of the lady, which the trial court relied wholly on convicting the accused appellant. But besides that, my lord, there are lots of witnesses which is totally contradicted the dying declaration because they were present at the time of occurrence. All the witnesses categorically stated that the husband, he was not present at the time of occurrence. And they have extinguished the fire when they have heard the sound. They came to the place of occurrence. They tried to save the girl and extinguish the fire.
So when did the incident occur, this burning?
Burning happened
2012,
31/5/2012. And when did
9
she,
PM.
at
Huh?
9 PM.
when did she die?
12/6/2012.
She died 12/6/2012. Within all this period, my lord, though there is a dying declaration, it is not recorded by any magistrate, my lord. There's no effort been made by the IO to record the dying declaration through the magistrate. I'll come to the dying declaration also. There's lots of infirmities in the dying declaration itself. But before going into that, all the witnesses, basically the PW 1, 2, 5, 6, 7, 8, and 11. They are all stated in tandem that the husband was not present at the time of occurrence. Hearing the hue and cry, they rushed to the place of occurrence. They tried to save the lady and extinguish the fire. And then they informed the husband. Thereafter, husband came along with his car after probably 15 minutes probably. Then he also tried to save the lady. He has took her to the hospital immediately. And in the hospital, after a few days, she has succumbed to the injuries, my lord. And there is an 80% burn injuries as per the medical report. Now, all the evidence which shows, my lord, the husband was not present. But the fact remains that the trial court, only relying to the dying declaration, convicted the husband. And there is no discussion in the judgment of the trial court why it was disbelieved, the statement of the eyewitnesses which was disbelieved. There is not a discussion.
How many prosecution witnesses?
There are altogether prosecution witnesses, my lord, 18. And the relevant are, my lord, 2, 5, 6, 8, 11. They are all the independent eyewitnesses.
Was she living with whom? With the father-in-law, mother-in-law?
Yes, yes,
Uh-huh.
yes.
All of them.
And there's a admission to the fact that, my lord, prior to the few days back, she was caught red-handed in a compromising position with a person. And there are witnesses also categorically stated that there is an eyewitness to that effect also. And thereafter, everybody has reprimanded her because of her relationship.
Any children?
Yes, there are children also. There are only 3 years, 2 children, my lord. One is 3 years, one is 12 years old. They were not examined, my lord. So, this is the basic case, my lord.
Hmm.
Now, the trial court convicted his husband on the basis of the dying declaration. Whereas, from the evidence of the dying declaration also it comes, my lord, it is absolutely not permissible to do. She has stated in Assamese and English, in the vernacular language, whatever she has said, to the doctor. And doctor has himself translated it into English. And he has translated to English in a different room. He has taken then he has wrote it of his own. Then he has wrote it in English. Neither it was read it over to the victim. There is no certificate also that it was read it over to the victim, and she has accepted to that.
Did she sign?
No.
Oh, no, nothing, no
No.
signature. nothing.
So, and it is admitted fact that it was in Assamese, translated, nobody certified, and in it translated in a different place.
But oral dying declaration also can be the basis.
Yes, can be, but it was written because the oral dying declaration was made to the doctor. Handwritten, and he took it in a paper, translated in a different place into English, but the original copy, handwritten copy, it was not exhibited. It was nowhere found. Only the translated type copy been placed, which has been exhibited. And there is no certificate to that effect that it was read over to the victim and she has accepted it. That's the basic requirement for proving a dying declaration, my lord. And if we go by the dying declaration also, the dying declaration is absolutely contradictory to the eyewitnesses. Which one to be believed? So here we get the two prosecution story, my lord, which can go together, my lord. One story, their own prosecution witnesses said that she has burnt herself. We tried to extinguish the fire. Husband was not there. He was informed. He rushed to the place of occurrence. Then he came and he took her to the hospital. That is
Okay,
one part.
Let us go.
Yes,
Now
my lord.
straight away.
The
to the-
straightway, my lord, the PW1, he is the hearsay, my lord, he is the informant, not very important. And he was informed by the PW4. He is also not there. PW2 is the main important, my lord. Independent witness, case 49. Mary, I know the informant Noor Hussain. I know the accused Nazmul Haq. The incident occurred in the 1 year, 3 or 4 months back. About 9:30 p.m. the incident occurred. At the time I was at my home. I heard the sound hue and cry accused Nazmul Haq's house, and I went to the running to his place. There I saw the accused Nazmul's wife Noor Fatima had fire on her body. Then I and my son, this is PW3, Anarul and Nazmul's father, Udrat Ali, torn the cloths and they extinguished the fire on Noor Fatima. Then my son Anarul called Nazmul over phone. Nazmul brought his magic vehicle, he's the appellant, my lord, magic vehicle, and took her Fatima to the hospital in the vehicle. After a few days, or after her treatment at the hospital, Noor Fatima died.
What is this magic vehicle?
Megan, it's a van, kind of a tempo. Name is the brand name is the magic. My house is near to the accused house prior to the 10 to 15 days. Prior to the 10 to 15 days of the incident, wife of the accused Noor Fatima was caught having sexual intercourse with Siraj Ali in a naked condition. This is very important. The incident was seen by the one girl named Yarana, PW11, my lord, who had narrated it to me. Later on, Noor Fatima admitted before public of having illicit sexual relation with the Siraj Ali. During their married life,
Siraj Ali is PW11.
PW11 is the Yarana.
Yeah.
Siraj Ali is not examined, my lord. Siraj Ali is her boyfriend, man. Having relationship with the Siraj Ali during their married life, Nazmul never. So after 3 days, at about 12 midnight, the doctor is recorded. But before that, there is no effort by the prosecution to record the statement by the magistrate.
I don't know, might not have been able, there might have been some problem. Any number of reasons can be there.
But here, any number of reasons can be there, but it has to come out, but that reason.
Did you cross-examine them? Why didn't you try to take her dying declaration?
Necessary, they have to establish, the prosecution has to establish their case beyond all reasonable doubt. It's not my case, my lord, it's their case. They have to establish.
No,
beyond
because
reasonable doubt.
you are trying to say
Yes,
that they could have asked the dying declaration
Yes.
at an earlier point of time.
yes, it is.
So the suggestion made by this court was it could have been due to any number of reasons.
No, that they have to establish that these are the reasons. That's why we failed to record the statement for those many days. It is their duty. Why they have recorded after 4 days at midnight? Why the doctor? Why the police has not tried to bring? Why he has not tried to record the statement? Why the magistrate was not taken to? When the girl was itself was unconscious at the time of the occurrence. When there is an 80% burn injuries, my lord. Is it my requirement? It is their requirement rather when there is a delay. Because question will definitely come why there is a delay. They have to put it, there is a reason for the delay. Their unexplained delay rather created doubts under the section evidence section 14, my lord. I am recording the dying declaration in Noor Fatima Dega, Dr. Tham. At the time of recording the dying declaration, Noor Fatima Begum, I along jury board of Mommy Dip Chaudhary were present. At the time of the giving dying declaration, Noor Fatima was in a sound state of mind. At the time of the giving dying declaration, Noor Fatima told while she came out from the house, then her husband and the other two persons got hold of her and poured kerosene on her body. Now, regarding the pouring kerosene, I'll come, my lord, on her body and set fire, and they threatened her by saying that if she tell the incident to anyone, then she will cause harm to her son. After recording the dying declaration, I put my signature on the statement as a witness. Exhibit 3 is the dying declaration of the Noor Fatima Begum. Exhibit 3.1 is my signature. 3.2 is the signature of the Dr. Thumb, which I acquainted with. Now cross-examination. Exhibit 3 is that there is no mention of the room number of the patient registration number. Exhibit 3, there is no certificate given by the doctor who recorded the statement of the victim as to the fact that at the time of making the statement, she was in a sound state of mind and she was physically capable of making statement. This is very important. When the statement of the victim was recorded, the statement was not typed out and it was typed in a separate room, and thereafter I put my signature in the statement. So the statement was typed out in a different room, then the witness statement has been taken in that particular document. I cannot say who typed out the statement. The Dr. A. Thumb first recorded the statement of the victim in a paper of his own hand, and thereafter it was typed out. I have not seen that original statement or in the court today, which was recorded by Dr. A. Thumb. Well, why this original was not put, my lord? Why it was concealed before the court? It's a very vital document. If that is the correct statement of the victim, it's rather created a doubt of the whole prosecution case that it was a concocted, fabricated document. Because Lordship knows I don't have to prove beyond reasonable doubt. My duty is only to, with the preponderance of probability, that's all my law. And here is apparently that has been done by the cross-examination itself. The victim gave her statement in a mixed Bengali and the Assamese, but it is in English. It is necessary to obtain the signature and the thumb impression of the victim after giving her statement. Exhibit 3, there is no signature or thumb impression of the victim. Lordship mark it again. Exhibit 3 is this, so there is no date below the signature of the thumb and myself. That's all very important. They say that the night, why there is no signature, no thumb impression, nothing. It is not a fact that Noor Fatima did not give any statement as to who was his serious condition was informed to the police, but I cannot say who in the police. It is not a fact that the exhibit 3 is a concocted one. That is our suggestion. Now 14, my lord, PW 106, my lord. On the last on 4/6/12, I was on duty of Lower Assam Hospital and the Research Center, Bongaigaon. I know Dr. Thumb. He is working at the said hospital as a surgeon. On 4/6/12, about 12 noon. Now it is 12 noon. The first doctor, he said it was midnight. Now it's come to 12 noon, my lord. 12:30, Dr. Thumb recorded the dying declaration. I was present at the time. Then Noor Fatima was mentally sound and the state of talking, giving the answers to the questions. When she was asked about her husband's name, she told that her name was Nazmul Haq. After recording the dying declaration, I put my signature on 3/3, the said dying declaration, and so signature. Now the cross-examination part is very important. In regard to the fact that Noor Fatima was in a sound mind, there is no fitness certificate enclosed with the exhibit 3. Noor Fatima's body got burned in the fire. There is no mention in Noor Fatima's room number, cabin number, or the registration number in exhibit 3. Noor Fatima spoke in Assamese language. When the victim gave statement, it should be recorded in their own language. Exhibit 3 was written in English. This is important, madam. Noor Fatima gave statement in Assamese language, but the doctor recorded its said statement in English. When Noor Fatima was given her statement, there was no type machine in the room. Now, where this type copy has come up, there is no explanation by the prosecution. Exhibit 3 was typed in a different room, and who has typed and who had typed the exhibit 3, I do not know. I have not seen the handwritten copy written by the doctor with exhibit 3. Again, madam. Original is missing. I put my signature on the typed copy of the exhibit 3. There is no signature of Noor Fatima in exhibit 3. There is no date mentioned below the signature. There is no date mentioned below the doctor's signature. That's very important. Why the doctor has not put their signature in the dying declaration? It is not the fact that Noor Fatima was not in a sound state of mind. These are the suggestions. Next one, my lord. The 14 doctor who recorded. Page 111.
No, tell me, PW number?
PW number 14.
Then what about page 106?
So there are two 14, my lord. One is as per the, one is 14 6 and one is Judy Boru, Judy Boru also 14 and Dr. Tham is also 14. 214. Maybe my lord, there's some mistake. The page 111. So he recorded the statement, my lord. I record the surgeon, I know the Judy Boru was working in the nursing in the superintendent of the Lower Assam Hospital. Dr. Akim Chaudhary, assistant surgeon, is known to him as working in the same hospital. I also know Mr. Mommy Dev Chaudhary, who is also the staff nurse in the same hospital. On 4/6/12 at 12:05 p.m., I have recorded the dying declaration of the one patient, Mr. Noor Fatima Begum, about 22 years, female daughter of so. At the time of recording the dying declaration, Noor Fatima Begum, Asim Chaudhary, assistant surgeon, Judy Boru, matron, Mommy Dev Chaudhary were present. At the time of the giving dying declaration, Noor Fatima Begum was in a sound state of mind. At the time of giving dying declaration, Mrs. Noor Fatima Begum told me that on 31st at about 10 p.m., when she came out to the house to go out to the toilet, her husband and Nazmul Haq, along with two more persons, came out and could not caught her and poured kerosene over the set her in the fire. Now, as per this dying declaration, it is all happened outside the place, inside, not inside the room. When she went to attend the nature's call, then the person caught hold of him. There, they poured kerosene and burned her. But the other prosecution story is that the all incident happened inside the house. Then she started screaming, and as soon as they started screaming, her husband put off the fire and threatened her that she would kill him and her child. He also told that when people asked how the accident took place, then she said that if it had happened accidentally while cooking. Now this is very important. Nobody has corroborated this part. This is for the first time in the dying declaration. Not a single witness of the prosecution case has said that out of fear, she has given a false statement because the husband has threatened her. Neither, not a single witness said that out of fear, she said it's an accidental fire. I was cooking. This is for the first time in the dying declaration it has come out, which has not been supported by any of the prosecution witnesses. That's how far this dying declaration is reliable. If there's a doubt in the minds of the dying declaration, the benefit should go to the accused itself. Then he immediately took her to the Abhayapuri hospital. Then, my lord, if my intention was to kill her and I have threatened her that you should not speak anything against me, that what is the reason for me to took her to the Abhayapuri hospital immediately to save her life? That is contradictory. Mrs. Noor Fatima Begum also says that she had told about the incident which took place in her house about 25 days before her husband, following which her husband did not behave with her. The incident was a person named Siraj, that she locality had come to her house at 7 p.m. in the morning when she was alone in her house and tried to sexually molest her. But she resisted, and then time a girl named Yarana from the neighborhood came to the house, and then the person Siraj left her house and fled away. Now this is her own statement that the Siraj came to her house and that Yarana, the PW 11, saw this incident, whereas the PW 11 are categorical statement that both are in a compromising position. She saw her, then she narrated the incident to another witness. She has also corroborated. So from her statement, it appears that the something had happened, but she has cooked up a new story in her dying declaration, which is not supported by the other prosecution witnesses. And if there is no FIR was lodged immediately after, if there is a trying of the sexual assault, because it has happened 20-25 days ago, then why she did not lodge any FIR? Why her mother, father not lodged any FIR? If the incident of the sexual assault had happened 20-30 days, 25 days before this incident. She immediately narrated the incident to her husband Nazmul Haq. Then she came home, but the husband did not react on that night on 31st May and set her on fire. Statement was recorded on 4/6 about 12. Statement was voluntary and recorded exactly as narrated by the patient. After recording the statement in presence of the witnesses, I put my signature in the statement. Now this is signature. All the witnesses says there is no signature of the doctor. All the witnesses who were present were independent. They said there is no signature of the doctor, no date was put. But he said, I put my signature in the statement. Exhibit 3 is the dying declaration of Noor Fatima Begum. Exhibit 3/2 is my signature on the Exhibit 3. Exhibit 3, I have not mentioned the room number of the patient and also registration number. I have not obtained any certificate in this regard that the time of incident, patient Noor Fatima Begum was at the stage of the second state of mind, the sound state of mind, and was capable of giving statement. At the time of recording statement of the patient, I have recorded the same by handwriting. This is admission, my lord. The handwriting statement is not before me. Exhibit 3 was typed copy in the room. I am unable to remember the name of the typist. This is absolutely one of unreasonable story, my lord. He recorded the statement in a vernacular or in his own handwriting. Then he went somewhere to type it out. He did not remember even who has typed it out. No signature. He said there is a signature. Other witnesses said there is no signature. Then the original copy is missing. Not read over also to the patient. There's no signature in the patient, thumb impression of the patient, if she was at all conscious at the time. Exhibit 3, I have not obtained the signature or the thumb impression of the victim because it was not possible because our hands were totally burned. But I said the fact I have not mentioned in Exhibit 3. So later on, but that fact was not put it in mentioned in Exhibit 3 that her burned, the finger was burned, or it was. That's why I could not take. That is not the case. But the said fact I did not have But the said fact I have not mentioned in Exhibit 3. Witness, including myself, have not mentioned the date below our signature. I have informed the police, but I have not mentioned in Exhibit 3. I am unable to say whether the police came or not. In effect, in Exhibit 3 is concocted.
Anything else?
Now, PW 18, page 123. My lordship, before that, I was going to that, page 122, post-mortem, my lord.
Yes.
On 16/6/12, I was serving as a senior medical officer, so and so, thereafter it was so and so. I performed the post-mortem examination of the dead body of Musamma for 22 years, female resident of so and so, identified the brought by the so and so. Abdul Haq, post-mortem examination, my opinion about the cause of death was due to shock and the result of 80% burn injury sustained by the disease. According the condition of the disease, essential postmortem report. Now the cross examination. That's important. Burn injury found our body of the disease may be caused by due to the accident or the burning. During the postmortem examination, I have not found any smell of kerosene oil on her body or clothes or disease victim. Whereas the victim in her dying declaration said that the kerosene was poured to her.
But it could be, you see, 16 days had elapsed by then.
Well, that could be, my lord,
16
but
days
it
had
could
gone.
be always goes in my favor. my lord.
Anyway, that smell though, who will,
But
to,
if that
to
is the dying
smell,
declaration,
have you smelled the dead animal after a week? I'm telling you,
but the kerosene and
you will not,
the kerosene, my lord, is always remains some kind of.
you will not be wanting to go near even a dead, after a dead body.
Kerosene and a dead body is totally different, my lord. But the kerosene. and
Anyway,
the-
that is something subjective, we do not know.
Yes, my lord, but it goes in my favor, that's what I'm saying. When nobody is sure, my lord, it goes in favor of the accused, that's the law, my lord.
Anyway,
Now, the PW 18, she was present, my lord. Everybody says that she was present, Mommy Dev Chaudhary. The doctor also said that she was present at the time
who
of
is
the,
she?
she is the matron, my lord. Nurse present at the time of the dying declaration as far as the doctor is concerned.
No, at that time there was some Juhi was there.
Yes, then mommy was
Juhi-
also there. Mommy is also there, man. They are 3%. They are total 4. Mommy was also present. Lordship can see the doctor's evidence itself. 13, 14, 18, all were present, my lord. There are 2, 14, my lord. Doctor is also 14. 13 was present. Mommy was also present.
Who says mommy was present?
The doctor himself said that mommy was present, my lord. 13 and 14 also says mommy was present.
Ah, yes.
Her signature also appears in the post exhibit 3, my lord, in the type copy, my lord. Page 123, man. Cross examination. I do not know the informant Nur Hussain. I do not know the accused Nazmul. I do not remember anything regarding the incident. I do not remember what I have given, for what I have given the signature. Exhibit 4 is my signature. She was not declared hostile. Now, cross examination is declined. Now, 125 is the dying declaration, my lord. This is a type copy, my lord. Not the original copy. But the doctor said it was handwritten by me in a piece of paper. Subsequently, I typed it out. Who typed? Where typed it? Do not remember. Mommy Dev's signature, lordship will find exhibit P by 3/4. Judy Boru's 14. Exhibit not marked, all Wasim Chaudhary exhibit 3, but this is a type copy. So all they have given the signature in the type copy now. That's admitted. So now whole case is now I am relying on the
So
few judgment.
the signatures are the original signatures.
Signatures are the original signature in the type copy. But the fact remains is the first of all, but the one thing is absent in the, that's more important part. That there is no certificate appended with these dying declaration. First of all, that she was capable of giving the statement. Always not necessary, but it should have been. Second one, why her signature was not taken, that's not there. And the third one, the why the statement when he has taken the statement in Asmir, why the original was kept concealed, why it was not placed, why it has been destroyed. That means it was destroyed, my lord. Why the original has been destroyed? When the original has been not placed, that means it was destroyed. We can't say what is the original. It's just translated copy only. And the fourth is the why it was not explained to the, if she is in a conscious state, she should have been read over and explain it to her. That is most mandatory part regarding the dying declaration. So I'll place few judgment for your lordship consideration, my lord.
It's, we should have heard the appeal.
Yes, my
Whereas,
sorry, I was thinking of in between, I did not
it's-
interrupt.
it's-
Lordship, what my learned friend is doing,
No,
the
no, no.
IA as well, order a mail appeal, your lordship.
Because I am 1.5 years behind the bar. For these
Hearing
particular
of the
waiting,
IA amounts to hearing of the entire appeal.
how long it will take, Mr. Council? Can you say when my appeal will be heard? When I can wait for the 1.5 years for my these petition minor? How long I have to wait for the appeal minor?
No, this IA has been filed only this year
No, that's true, my lord.
and also filed only in July, not,
July, August,
not-
September, October.
just-
Because the
just
LCR,
three-
we have to wait for the LCR, my lord.
just 2 months only.
That's LCR, we have to wait for the LCR. Because all the time, if the LCR doesn't come, then the
Otherwise,
prosecution
it'll
said,
be amount to disposing of the
Yes,
entire
your
thing.
lordship.
to dispose it of by making it a part hard, my lord, dispose it of, I have no option, my lord. I'll be rather happy
Has to be prepared.
than the paper book. They,
Short
they,
date be
they will
given.
definitely, now they will come that the paper book is required.
I have not come, I have not done.
No, they
I have not
definitely
yet.
they will come, my lord. They want to keep me inside for their own, not for the other reason. They should be
The-
fair enough.
whatever
They should be
plea-
fair
No,
enough.
hey, cool down,
Let him
cool down.
complete-
There's
yes, let him
nothing,
complete his part.
there's nothing
That
to be
it does not
agitated.
stop me for, like, she should have stopped me for earlier. I was
I'm
answering
not
the case.
interrupting you. He's making his argument. Let him complete his part. He's almost finished, my lord.
Then after finishing the, what is the reason?
No, you see, the only thing is that it's basically where if we go to that extent, we'll be deciding the entire
Entire
case.
appeal.
No, my lord,
You know.
this is not the case, my lord. Lordship has to prima facie satisfaction that the case is a bail or
That's
not.
Because we have gone so in depth.
So that's why the
Yes,
lordship will only go through the judgment.
In
only
IA,
see
your
two
lordship
judge-
has to see if they have a
Yes,
prima
okay.
facie case to lordship that.
Yeah, I have read all the judgment. If lordship is
Suspension
not
sentence,
satisfied,
my lord.
reject my case, my lord. If lordship is not satisfied with this case, my lord, well, all the prosecution
It's-
cases
it's
in my
not-
favor.
It's not that, Mr. Council. Now I'll have to give an equal amount of time to her.
No, give her the
Another
time. I
problem.
am not objecting to her. They have already filed their objection to it. It's not that they have not filed the objection. They have got the ample time to file the objection. It's not a case that today I'm arguing. They have filed their objection. Now they are coming with that they know it has to be hard. They have not put up that story in the objection that it should be hard in the. And now they are saying that the paper book has to be ready. I can understand that. But when it will come again, so much pain I have, so much trouble I have taken, and lordship is there's a prima facie case of acquittal. When there's a prima facie case of acquittal, and I can place the judgment before your lordship. There
You
are
give
three
me,
judgments.
you just, yes, okay, not more than that.
Lordship, the entire matter be hard, your lordship, since he's like reading out all the evidences.
No, we'll
Is it-
see, just give me those three
Yes.
judgments. No, not more than that. Not more than that.
Yes. I'm just reading the two judgment requirement of this.
Yes, make it, that's all. Two is enough, then two is enough, that's all.
No, I
No more.
because it's today it has come up for consideration
give
of
me-
the
give me, you
Alabama
give me.
law.
Let us
You
continue,
give
my
me
lord.
that. You
I'll
give me
not
that.
argue, my lord.
No, no, you give me that.
That's the way of doing things, my lord.
Mr.
The lordship is asking
No,
for the
yes,
judgment.
that's
Why?
part.
The lordship
Lordship-
is asking me for the judgment and she is objecting to
me-
that.
oh,
Judgment
I
placing the
haven't
judgment.
brought
What
the
You just
citation.
give me that.
He misunderstood.
You just give me
That's
that.
not hard it.
You just
I
give
have
me that.
heard it after the lordship has
I have
asked me.
not brought the any
But then
citations
It's your
because
problem, my lord. It's not my
it has
problem.
come up for consideration of interim lordship IA, my lord.
Am I?
If you
defer-
are-
Just give me those two judgments.
Yes, so
That's all.
if your lordship, I'll give them tomorrow, I'll give my part, I'll do it tomorrow. Because I have got judgments, I have not brought it, my lord, but it's written in my diary.
I'm not stopping her placing the 100th of judgment. I'm just placing 2 of the judgment. Let me place it. There's a limit to it.
Yes, which paragraph?
Paragraph, my lord,
23.
2023
Yes.
SCC online
Yeah.
1060, just very recent judgment.
Para.
Paragraph, my lord, 40, 41. 41. 47 fighting onwards, my lord. 47, lordship kindly see directly, my lord. In this case, death sentence was awarded on the basis of dying declaration, my lord. Lordship kindly. Trial court convicted in 302 on the basis of the death sentence has been granted High Court has confirmed the death sentence. Supreme Court has acquitted this man on 2023. Oral evidence and dying declaration is contradictory. That's the reason for acquittal, my lord. I'll come to that finding, my lord, paragraph 47, my lord. The overall assessment, has your lordship got it, madam?
Yeah.
The overall assessment of this material on record, we have reached to the conclusion that neither of the two dying declaration inspire any confidence, nor the oral evidence of PW 2 and 4 respectively inspired any confidence. Had the dying declaration stood corroborated by the oral evidence, the PW 2 and 4, then probably we have been altogether different scenario. However, as noted above, two dying declarations are not consistent and rather contradictory to the oral evidence on record. Same is our case, my lord. Rather contradictory to the oral evidence on record. That is the main part. This is why
Okay, and then the next case,
next case is the my lord,
para,
the Kashi Vishwanath, my lord, 2013,
Yeah.
17, 162, paragraph 30, my lord.
Yeah.
Paragraph 30. Here also, my lord, trial court convicted on 302, High Court also affirmed the conviction. Supreme Court appeal was allowed, he was acquittal. It was also case of a dying declaration, not supported. Paragraph 30, my lord. The prosecution has failed to state as to why 3 dying declaration was recorded in Kannada. If the deceased Nilmana was talking in Telugu, it was also not been clear as to who amongst the Tahsildar, PSI, SI or doctor who has signed so and so had knowledge of Telugu and translated the same in the Kannada for writing dying declaration in these exhibits. And at the bottom of the 3 dying declaration, it has not been mentioned that they were read over to the Kannada and explained in Telugu and that the disease understood the contents of the same. That's all.
okay, yes.
Lordship, at the inception, your lordship rightly observed, is it a case of honor killing? It is, your lordship, and the perpetrator is the husband, your lordship, because person dying will not lie, your lordship, before her death. As if the relationship between the husband and wife was cordial, she will not have named the accused person to be the perpetrator. And the reason of killing is another person in the name of, I don't remember the name, your lordship, because according to the defense, she was found along with another person, your lordship. Lordship, may I take your lordship to the dying declaration part at page number 125? If the dying declaration is truthful, it can be the sole basis of conviction, and there is no lordship corroboration necessary. Supreme Court says, or as per the various judgments of Honorable Supreme Court, my lord. Page number 125. The patient gave the following statement while she was admitted in Lower Assam Primary for treatment. The patient, Mr. Nur Fatima Begum, aged about 22 years, female, daughter of Nur Hussain and Eliza Khatun, and wife of Mr. Nazmul Haq of village Khargaon, said in sound state of mind, your lordship will kindly note that. She was in a sound state of mind that on May 31st at about 10 p.m., when she came out of her house to go to toilet, her husband, Mr. Najmul Haq, along with 2 more persons whom she could not recognize, caught her and poured kerosene over her and set her on fire. She then started screaming, and as soon as she started screaming, her husband put off the fire and threatened her that he would kill her and also her child. He also told her that when people asked how the accident took place, then she should say that it happened accidentally while cooking. He then immediately took her to the Abhayapuri hospital. The patient also says that she had told about an incident which took place in her house about 25 days before to her husband, following which her husband did not behave well with her. The incident is that a person named Sires of the locality had come to her house about 7 a.m. in the morning when she was alone in her house and tried to sexually molest her, but she resisted, and at that time, a girl named Yarana from her neighborhood came to the house, and then the person Sires left her and fled. She immediately narrated this incident to her husband, Nazmul Haq, when she came home, but her husband did not react, and on that night, 31st May, set her on fire. The statement was recorded on 4/6 at 12:05 PM. The statement is voluntary and is recorded exactly and so and so. The learned counsel for the defense is harping on whether no case was filed against this series, your lordship, by the parents. Why parents should come up and lodge the affair when husband is there beside her, and the allegation and the lordship, whatever has happened, incident has been elaborated to her. He did not do anything, your lordship. Now, your lordship, just to lordship save their skin, now they have taken a plea, and whatever plea my learned friend has taken, your lordship, that the lordship that regarding the doctor, evidence of doctor, those pleas has not been, he was not confronted as regards why the original copy was not produced, why it is the translated, the original version was not produced. Is it a lordship type copy or manipulated one? All those lordship evidence is not on record, your lordship. So at this stage, whether he can, your lordship, can take those all those pleas. And in this regard, lordship, may I take your lordship two judgments? I don't have the hard copy today. Lordship, may I rely on 2014 SCC 646, Prem Kumar Gulati versus State of Haryana. If dying declaration is truthful and reliable, without corroboration may form sole basis for conviction. In our case, it's truthful and reliable. And your lordship, another plea has been taken by my learned friend that when the incident has taken place earlier, way back in May, your lordship, it was in 31/5/2020. Why that dying declaration is recorded later on 8/5, your lordship? It is because of the reason when she was admitted, she was not in a, she was 80% burned. Subsequently, because it can be lordship, it can be gathered because immediately the patient did not die. She died subsequently, your lordship, on 12/6, that is after 12 days. So, your lordship, it's up to the doctor who has recorded the dying declaration. And as per the lordship, may I take one more judgment? It is, my lord, the 2010-14 SCC 200, Ompal Singh versus State of UP. Person who records dying declaration must be satisfied that deceased was in a fit state of mind. So, doctor who have come up before the learned court below, he has specifically deposed before this honorable, before the learned court below, that the victim was in a fit state of mind. So it's up to the doctor who recorded a dying declaration. It's mental satisfaction. She was in a fit state of mind to give a dying declaration. And it was recorded, lordship, it has come up with on evidence that as her hands were burned, so thumb impression could not be taken. So entire evidence is,
Where is the evidence?
it's there, your lordship. I have read while reading by my learned friend. May I take the evidence of PW 14?
Come. 14. That is at page 111, 111.
Yes, lordship.
PW 14A statement,
Yes.
page
Thank you.
112, my lord, in the cross-examination part. That I have read already. But our case is that it was not reflected in that particular dying declaration.
Lordship, last 6 line, the patient narrated
I've
has
got it.
taken, yes. Fine. So she was in a fit state of mind. There's nothing to disbelieve her statement, your lordship, made before her death. Because it was,
What about the evidence given by the prosecution witness?
yes. So may I am citing 2014 SCC. Corroboration is not necessary. When honorable court found the evidence of the victim is truthful. Corroboration is not necessary. I could not refer the citations, my lord. I do not have the hard copy.
2010
2014, 14 SCC 646.
and the other one was
Other one
2000.
was 2010, 14 SCC 200. Person who records dying declaration must be satisfied that this was in a fit state of mind. Para 24 to 26.
So what becomes of what is the value of those prosecution witnesses evidence?
Oral dying declaration vis-a-vis the dying declaration. If your lordship comes to a finding that the evidence given, the statement given by the person dying Lordship is truthful, then nothing to disbelieve. Vis-a-vis although the certificate is not there, but evidence has come up on record that she was in a fit state of mind. These official witnesses, there's nothing to disbelieve them. They are not like anybody's witness, PW, a prosecution witness or a defense witness, my lord. They're official witnesses. There's nothing to disbelieve them, my lord.
What about them saying that, one of them saying that they had called up the husband and then he came to pick her up?
Lordship, your lordship knows your lordship at the time of commission of the crime. And it's within the domestic relation. There's no possibility that other persons would come. After hearing scream, only neighbors come in most of the cases, my lord. So your lordship, this person has, after committing the crime, might have fled away. Because they have called him over phone and immediately he came over. He was in the vicinity of the residence, my lord.
That's all.
So, lordship, enter matter be heard, your lordship. Enter matter, lordship, I may not be allowed. My respectful submission is that, your lordship. Since the LCR is there, your lordship, the director is to prepare the paper books.
Well, I'm just 2-3 points, my lord. I'm just want to say, my lord, regarding the honor killing that she has said. Well, where is the evidence of honor killing? My lord?
There's no evidence.
There's no evidence of honor killing. Where she found it, I'm surprised. Then regarding Siraj, it is an admitted fact, my lord.
But then how does that has any connection with the
Yes,
death of?
it may not have, my lord. She might have committed. That's a
That's speculation.
That's a speculation.
Yeah,
That
that also-
but it goes in favor of because
Doesn't
the-
go in favor of anybody.
no, my lord. Because the witnesses say she committed suicide because of her own
How?
act. They say. So
How can they just,
no,
they
no.
can
So
say
that goes in favor of the.
no, that doesn't go in favor of anybody.
No, no. Definitely, it goes in my favor because this is a prosecution case, my lord.
It does not say anything. It does not say that, it does not prove that she committed suicide.
No, does not prove. But she was silent after the incident. That part is admitted.
You see, that is one
And
aspect.
she has admitted her guilt. That is one part. And the second part, and the argument is that regarding the lordship has rightly put up that what is the value of the prosecution witnesses with regard to the dying declaration. So the judgment she has cited that absolutely there is no doubt about it. When there is a dying declaration is truthful, we don't need any corroboration. But this is not a corroboration, my lord. This is a contradiction. That she has to understand that. Both are different. The cases I have cited, it's not a case of corroboration. When there is no corroboration, we don't need any corroboration regarding if the dying declaration is absolutely truthful. But here what is happening? It's a contradictory. When it is contradictory, then the dying declaration has to be belied. So that's why the lordship has rightly pointed out what is the value of those prosecution witnesses. And the one prosecution witness said how they have not declared him hostile. That one prosecution witness categorically said that on that particular day, he went on in the morning with his magic truck for his work, and he returned back on being informed by us over his mobile phone. That means on whole day he was absent. He was not declared hostile. That how they can belie that statement? Now how we can presume that husband was present, he committed the murder, then he fled away.
I think we have heard, Mr. Anthony. We have heard, they are repeating what you are saying.
And the husband has said he tried to extinguish
And there is no plea under 313, your lordship.
the 313. Why should I take the plea? When there is no evidence against me. 313 is the wording 313, the evidence which goes against me. I have to contradict those evidence, the material which goes against me. If there is no material against me, why should I bring up those material in 313? That's an absurd proposition, my lord. That's all, my lord. I leave it to your lordship, my lord.
Okay, right. In the main appeal, you're right. As LCR has arrived, registry to prepare for the paper book, lists the matter after 4 weeks. Then in the IA, you write, heard Mr. Anshuman Bora, learned senior counsel for the applicant. Also heard Ms. B. Boyan, learned additional PP. This application under section 389(3) CRPC has been made to suspend the sentence imposed upon the applicant as the applicant had been convicted by judgment and order dated 24/8/22 passed by the learned additional sessions judge bracket FTC, North Salmara, Abhaya Puri in sessions case number 126 bracket J/2012 under section 302 IPC and sentenced to undergo rigorous imprisonment for life with a fine of rupees 50,000, in default to undergo RI for 3 years. The petitioner had been convicted on the charge of having killed his wife by pouring kerosene over her on 30/5/2012 at around 8 p.m. At around what time?
10 p.m.
At around 10 p.m. Full stop. The wife was thereafter taken to hospital and she succumbed to her injuries on 12/6/2012. Full stop. The prosecution has had examined. No, the trial court had examined 15 prosecution witnesses.
18th, 1/8.
No,
Yes, ma'am.
I think only 15. 9 and there's no PW9, there's no PW10, at least in your application is not there. I have not been able to find them.
Yes, ma'am.
The Learned Trial Court had examined 15 prosecution witnesses in terms of the application filed by the applicant, as there is no evidence annexed with respect to PW 9, 10, 12, and 12.
It is on record,
You know-
PW9.
Huh?
I found it, original record, it is there.
What? They've given evidence.
They have given evidence.
PW9.
It is not there in your application then.
Because they are not relevant.
PW.
All are hostile, they are not relevant. That's why I'm not.
Oh, but then it was your duty to have put it, since you have placed already 15, another 3 more would not have changed anything.
Yes, that I, but this is on record, Lordship can go through it also.
No, but I'm just going through your records, no?
And the LCR has called for that, so am I. No? The,
And you asked it as per your application, doesn't make it.
they're all hostile.
Okay,
That's what-
okay, what have I said?
I'm sorry, man. for that.
And there are 18 prosecution witness. Now, of course, though, only 15 testimonies of the prosecution witnesses have been annexed to the application, to the present application. The learned counsel for the applicants submits that a perusal of the evidence of PW 2 to 11 is basically to the effect that no, not 2 to 11, it's PW 2567, no, 2568 and 11 is to the effect that on hearing a hue and cry in the house of the applicant, they went running to the said place, where they found the applicant's wife, Noor Fatima, on fire. After the fire was extinguished, the husband of the petitioner was called, the husband of Noor Fatima was called over phone, full stop. The applicant then arrived in his vehicle and took his wife to the hospital. Noor Fatima thereafter succumbed to her injuries a few days later, that is on 12/6/2012. The learned counsel for the appellant also submits that the wife of the applicant had also been caught in a compromising position with one Siraj Ali. And due to her shame, she had apparently committed suicide by burning herself. Full stop. He also submits that the learned trial court had convicted the appellant only on the basis of the dying declaration made by the deceased, which was apparently recorded by Dr. A. Than, Than, Tham, Dr. A. Tham. Full stop. The dying declaration, as per the evidence, the dying declaration had been made in Assamese by the deceased, and the same was recorded by Dr. A. Tham, who then went to another room and had the same typed out in English. He submits that though the typed out dying declaration, which was exhibited as EXT3, was signed by the matron PW14 and by one Dr. A. Chowdhury PW13 and the matron 125 by one Dr. A. Chowdhury PW13, the matron PW14 and
18.
and PW18.
Yes.
Thumb did not sign. Did Thumb sign? Yeah, and Dr. A. Thumb, the original dying declaration, which had been recorded by Dr. A. Thumb in English, in Assamese, is it? In
Assamese and Bengali.
In Assamese and Bengali, had not been produced by the said doctor. He submits that as the evidence of the prosecution witnesses is not consistent with the dying declaration made by the deceased, the dying declaration cannot be made the basis for convicting the applicant. Full stop. In this regard, he has relied upon the no, he submits that the above is due to the fact that the manner in which the original dying declaration has not been produced, and as the evidence of the doctors with regard to the recording of the dying declaration creates a doubt on the contents of the dying declaration, comma, the
Not read over to the
comma which was not read over to the deceased, comma, the uh, the sentence imposed upon the applicant should be suspended. And the applicant should be released on bail. Full stop. In support of his submission, comma, he has relied upon the judgments of the apex court in the case of Dash versus Dash reported in 2013, 7 SCC 162, and in the case of Dash versus Dash 2023 SCC online SC 1060. Full stop. Next para. On the other hand, the learned additional PP submits that when the dying declaration is found to be truthful and reliable and inspires the confidence of the court, comma, conviction can be safely made by the learned trial court. Full stop. He submits that there is nothing to doubt the veracity of the dying declaration made by the deceased. And in terms of the judgment of the Supreme Court in the case of Dash versus Dash, comma, 2014, 14 SCC 646, and Dash versus Dash reported in 2010, 14 SCC 200, comma, there is no infirmity. There is no reason to interfere with the sentence imposed upon the applicant. Anything else?
2010 14 as regarding the satisfaction of the person who records the dying declaration.
She, full stop, she submit that she submits that the dying declaration of the applicant of the deceased having been recorded by the doctor who was treating the applicant, comma, the satisfaction of the said doctor who had recorded the dying declaration was enough to inspire to come to a finding that the dying declaration was truthful and reliable,
Disease was in a fixed state of mind.
and that the disease was in a fixed state of as the disease was in a fixed state of as such. There's no reason to interfere with the certificate, so the application should be accordingly dismissed. Okay, we'll pass the order later on. Where do we have one? The relevant portion will decide. Order reserved. Huh?
Mala.
highly object.
Yes, Mr. Ali.
Yes, please, your lordship.
Yeah,
Lordship,
fine,
the
that
live
you-
stream, yes, live streaming be stopped.
Okay, live streaming, let's stop it. Yeah,
Other witness lordship will file.
just a minute.
Yes.
Who is this headmistress?
Had
PW?
this, Lordship, on last occasion, Lordship, I filed an application for adducing additional evidence during appellate stage also. That Lordship has heard and according to Lordship dispute that.
Where is the FIR? Is that page
Lordship.
17?
Yes. Starting from 19, Lordship. In the FIR, their name is mentioned. Lordship.
Yes,
In fact,
Madam Raviram Das not mentioned anywhere.
the initial witnesses were only witnesses to the surrender and the so-called confession before the police. They went and surrendered and they were found. The Raviram was one of them.
Raviram surrendered.
Raviram surrendered.
Lordship, yes, as per their story, Lordship, he has surrendered, but he, in fact, Lordship didn't surrender, he was arrested, Lordship.
Lordship, it is there in PW
Oh,
7
they-
statement
Yes.
that Raviram, Ratul and Prafulla surrendered before
Yes.
during my presence at the place of occurrence. Some people came there from Barama Bazaar and they informed me that accused Raviram, Ratul and so surrendered before the police of Barama police station after killing the deceased.
Yes.
Are those accused persons are present before the
PW7.
court? PW 7.
And in cross part, Lordship, you see the cross part of PW 7. In the page
Yes.
43.
Yes.
I cannot remember now the week of the day of occurrence. Place of occurrence is situated at a distance of less than half kilometer from my house. It is the fact that I did not state to police that I noticed the cut mark on the neck and leg of the deceased. Police asked my name only, but did not record my statement. So Lordship, police even did not record his statement. How Lordship this evidence can be Lordship accepted to convict a person? Disease was a member of NDFB and he subsequently surrendered. I do not know whether the disease after his surrender used to demand money from public. So Lordship,
So did you give 164 statement?
no,
No,
Lordship,
sirs, the confession was made only by two.
only by one.
One, Prafulla and Raviram
No,
declined.
Ratul, only Ratul.
Acha, only Ratul.
All are hearsay witnesses, no eyewitness is there. And their statement are contradictory to each other also.
In fact, before surrender, there is no evidence at all. No evidence.
And the statement or evidence of IO is also Lordship cloudy Lordship. His evidence cannot be accepted also.
Ah. But go to page 50. This is the evidence of CW1.
CW, yes. Page 50 Lordship.
Yes,
50, 50.
50.
50. And this is with regard to her age, 50.
Page 50. Deposition of court witness number 1,
Lordship.
CW1.
50 is the three-one
Here
three
is lordship
statement.
some
No.
pagination.
Pagination is
Page 54 it is there. PW
54.
54. CW1. This statement is contradictory with the statement given by the lordship IO.
54 is my three-one three. CW1. CW1.
GDE entry number so and so.
Lordship, yes.
Says that 1, 2, 3, 1, 2, 3
Yes.
appeared in person with one knife
Yes.
and verbally
Bloodstain.
informed that they had killed on Govinda.
And that too was a bloodstain knife. Bloodstains were noticed on the garments and the knife.
It was not, it was lordship, but
It's
that
not
was there, but not sent for forensic.
That's
lordship
the,
examination.
Huh?
not,
It was not sent for lordship examination in forensic laboratory. Lordship. And the cross part lordship will see cross part of CW1.
Hmm.
He has stated that SI Saradas made the say GDMP. SI Saradas.
No, but then
Yes.
he has only read
No,
out,
that is true. Lordship.
he has read out what is written in the GD.
Yes, in the lordship evidence of IO, he has stated that he lost the lordship GDMP. That is at page PW 12. Provin Farali. In my here lordship page number 49, that may be different lordship. PW 12. Provin Farali lordship, but Provin Farali. PW12.
Confession to police. He just did not because.
these were.
Confession of the two accused.
I think there are only three circumstances here. And one is the surrender. Second is the confession of the co-accused. And the third will be a link, his false explanation under 313.
All lordship, these events are lordship missing with each other. There is no link of the color.
In certain cases, the chain may be very short. It is there, it is held by the Supreme Court. So here the chain is short, yes. But then the fact is within half an hour, they went and surrendered. Until they surrendered, in fact, the crime had not come into the picture. The police came to know only when they surrendered. And this was established by so many witnesses, surrendering with the bloodstained knife and the clothes.
And their statements are all contradictory. Lordship will find.
But at the end of the day, you have surrendered.
No, lordship, thing is that,
What you did not surrender, you arrested.
no, I was arrested. Lordship.
This is what his explanation 313.
Yes,
But that
in
was.
313
considered
lordship,
to
I
be-
have not explained because no such question was put lordship. 313 lordship.
No,
Had
no,
there
that
been such
was-
question lordship, I definitely I would have lost to reply. to the
No, no,
question.
that was put and he said he was arrested. Go to
Nothing
that
has been
question.
mentioned, lordship, regarding arrest. Only lordship, the Ratul Das has stated that lordship, he was arrested. Since lordship, there is no eyewitness lordship, thus I am going to rely upon only one judgment of opinion.
You have only said deposition is the call deposition. You have not given an explanation.
No, lordship, explanation, lordship, the question put to this person, lordship, he has got denied it, it was false evidence, or evidence by this person. Yes.
This and
Yes.
surrendered at Burma PS.
This is
The
by,
deposition is false.
Yes. That deposition is, yes, Lord. So, and
but Ratul had said that they were arrested. Police came at night, apprehended us and took us away. We didn't surrender.
Okay, right. I think we're fine.
And the confession of Ratul is there.
Lordship going to dispose of this.
Yes, yes,
Lordship, I am going to just rely upon one judgment also.
yes, yes.
If Lordship, if the case is based on the circumstantial evidence, Lordship, it is a duty of the prosecution to case the.
This is not the, this is, we're not
It is
going
a
into
case
the
of
appeal.
Lordship, complete case of Lordship circumstantial evidence.
Okay.
Lordship,
You-
kindly have,
you-
yes.
Heard Mr. J. Kalita, learned counsel for the applicant. Also heard Ms. S. Jahan, addition 50. This application under section 389(3) CRPC is for suspending the sentence passed in the impugned judgment and order. The impugned judgment dated 16/11/2011,
2021 Lordship, type again.
2021.
21,
16/11/21 passed by the Sessions Judge, Baksa, Mushalpur in Sessions case number 233/18, by which the applicant has been convicted under section 302/34 IPC. The applicant's counsel submits that there is nothing in the evidence recorded by the prosecution witnesses showing the involvement of the applicant in the crime of murder, in the crime in which one Gobinda Ramchiari, Gobinda Ramchiary, had been killed. He submits that the applicant had no hand in the killing of the deceased with a knife. On the other hand, first up, he submits that he submits that
Paragraph 22, Lordship, the last page. Page number 17, Lordship. I have just highlighted the Lordship.
he submits that the applicant has been convicted on the basis of circumstantial evidence. And as such, the circumstantial evidence must rule out any likelihood of the innocence of an accused. He submits that in a case of conviction on the basis of circumstantial evidence, all the links in the chain of events should form an irresistible conclusion about the guilt of the accused. And the guilt must be proved beyond all reasonable doubt. In this regard, he has relied upon the judgment of the Supreme Court in the case of A. Jayaram and another versus State of AP, by CBI, reported in AIR 1995 SC 2128. Next para. Ms. S. Jahan, additional PP, on the other hand, submits that the applicant and two other persons had, after killing the deceased with a knife, surrendered themselves before the police station with the bloodied knife, IED, bloodied knife. He submits that the circumstantial evidence to the effect that the applicant had surrendered himself with a bloodied knife along with two others proves the guilt of the applicant. She also submits that the applicant had surrendered within half an hour,
Yes, within.
within half an hour of the occurrence of the crime. And as such, the application for suspension of the sentence and bail should be rejected. Full stop. We have heard the learned counsel for the parties. And on perusing the evidence of court witness -1 bracket CW1, we find that the applicant had surrendered along with two co-accused. No, with two accused in the police station with a 10-inch knife which was bloodstained. Full stop. Full stop. On considering the evidence of PCW -1 and the evidence of PW12, we are of the view that the sentence inflicted upon the applicant should not be suspended, cannot be suspended at this stage. So accordingly, the application for suspension of the sentence and prayer for bail is rejected. I accordingly dispose.
Main appeal on 711 laws. Main appeal on 711 laws, just fix on. Laws.
Don't worry,
Laws,
we'll do that.
laws. Oblige laws.
Mr. Kuar is suffering from some sore throat.
Yes, ma'am. That's
Very
why he's
severe.
Okay, right. Mr. Which Kumar?
BD
Mr.
Kuar.
P. Kumar, Ashok.
BD.
BD
Yes.
Kuar.
Okay, right. Adjournment has been made on behalf of Mr. BD Kumar, learned senior counsel, on the ground that he's suffering from severe throat. Through a severe throat infection. Ms. S. Dahan, additional PP submits that she has got no objection to the prayer for adjournment.
Told me last night.
Accordingly, this matter after,
Your lordship, can it be fixed, the second week of October?
okay, when do you want?
It's to your lordship.
Accordingly, this matter in the second week of October.
Second week of October.
Ashok.
What is this matter?
Appeal against acquittal. Against acquittal, Your Lord.
Appeal against the acquittal.
My lord.
Appeal by whom?
Appeal by the victim, Your Lord. Victim,
Victims,
wife of the deceased.
okay,
Wife.
victim's wife.
Appellant himself, herself a victim.
Any chance of finishing today? How long will you take?
My lord.
Okay, what is it is
I will not take much time. Your Lord.
302,
Yes, Your Lord. 309.
149. All acquitted.
Main accused, that is Rahim Ali, who stabbed the deceased, he already died. Lord. So others were convicted for lesser offense.
The others were convicted
For lesser offense.
for lesser offense, not for
Yes.
302.
Not for 302. They were convicted under section Lordship.
Okay, but so he wants to put them under 302.
302.
We can hear, no problem.
Just 149 is there, and the total 11 which were PWs are there.
Okay, we can start.
On merit may be decided, but I am also facing some problem. Since after filing this case, I have no contact with the appellant, your lordship.
Huh?
Since after filing this case, I have no contact with the appellant also, your lordship.
So
Anyway,
that is, you see, that is your problem, not ours. So you cannot burden us with your problem.
Right.
Your problem, you solve it. Then the problem you give us, we will solve it.
right.
So you decide whether you want to hear this matter or you want to talk to your client, ask them, or what do you want to do? What is your final decision? If you, because like I said, we're ready if you want to do it, but then if you want to talk to your client,
My lord, I failed to talk with the client, my lord. I could not contact. Anyway, my lord, I will not take much time, my lord. I start this.
no, you see, you cannot do two things.
My-
You cannot say you want to talk to your client and also hear the matter. It's either you want to hear the matter, otherwise you want to talk to your client, you talk to your client.
I hear this matter.
He wants to do the matter.
My
Lordship, after hearing the lordship, acquitted, acquitted.
Naturally.
contact করিব পারা নাই।
In the meantime, during vacation time, you may contact with his client.
My lord, then after vacation, I will take it.
Prosecution is not, the other side is not willing to hear it again. Okay. No, why don't you contact your client? When phone call, just mobile. They don't have mobile. You don't have their number.
No number.
Huh?
I don't have the number, which was earlier used to contact with me, my lord.
When did you last contact them?
My lord, about 3 years back. your
3 years back.
my lord.
Oh. Look, what we can do is we can fix it next week also. You talk to them this week. Look, because it's your case. It's not it's their case. If they're not interested, it's their problem.
Otherwise, I'm with him, I'm for the prosecution,
Uh-huh.
he's for the inform, part of the victim.
Yes. I do not know, depending upon you. If you all are ready, we are ready. If you are, you give a date, otherwise. She's not ready, she's not interested.
I'm with him, Lordship, I don't know how much time. we will have to complete.
Take some stand, because Lordship, they are relying on 149. I have to place entire evidence that there is no common intention at all. Because it is admitted from, it is appeared from the evidence Lordship that Rahim Ali who suddenly came and stabbed the deceased. So there was no common intent. So I have to place the evidence on.
So
record.
there was a fight and this fellow suddenly came
Yes.
out of
Yes.
nowhere
Yes.
Yes. between two families.
Two families. That was the case. So I have to place the entire evidence.
After the vacation,
Fine.
I love it.
Then after vacation, may be taken up and my lord. 26.
No, more than that, it's not a question of after vacation. It's a question of can you contact your client? You see, there are two aspects to this. Either one is you want to do this matter without contacting your clients, or you want to do this matter after contacting your clients. Please be sure. What do you want to do?
My lord, actually, I tried to contact with my client, but I failed to contact. Anyway, I want to do this case here.
You want to do this. So without contacting, he wants to.
Right.
Then when do you want?
Then after that, then maybe can.
Right, on the prayer for adjournment made by Mr. A. Raman, Learned Counsel for the appellant, this is the matter after the case. So, operation successful, Ms. Brian.
Yes, sir. All right.
Let's